Mathews v. Eldridge. Justice Powell delivered the opinion of the court. The issue in this case is whether the Due Process Clause of the Fifth Amendment requires that prior to the termination of Social Security disability payment, the recipient be afforded an opportunity for an evidentiary hearing. Cash benefits are provided to workers during periods in which they are completely disabled under the Disability Insurance Benefits Program created by the 1956 amendments to Title II of the Social Security Act. Respondent Eldridge was first awarded benefits in June 1968. In March 1972, he received a questionnaire from the state agency charged with monitoring his medical condition. Eldridge completed the questionnaire indicating that his condition had not improved and identifying the medical sources, including physicians from whom he had received treatment recently. The state agency then obtained reports from his physician and a psychiatric consultant. After considering these reports and other information in his file, the agency informed Eldridge by letter that it had made a tentative determination that his disability had ceased in May 1972. The letter included a statement of reasons for the proposed termination of benefits and advised Eldridge that he might request reasonable time in which to obtain and submit additional information pertaining to his condition. In his written response, Eldridge disputed one characterization of his medical condition and indicated that the agency already had enough evidence to establish his disability. The state agency then made its final determination that he had ceased to be disabled in May 1972. This determination was accepted by the Social Security Administration, which notified Eldridge in July that his benefits would terminate after that month. The notification also advised him of his right to seek reconsideration by the state agency of this initial determination within 6 months. Instead of requesting reconsideration, Eldridge commenced this action challenging the constitutional validity of the administrative procedures established by the Secretary of Health, Education, and Welfare for assessing whether there exists a continued disability. He sought an immediate reinstatement of benefits pending a hearing of the issue of his disability. Procedural due process imposes constraints on governmental decisions which deprive individuals of liberty or property interests within the meaning of the Due Process Clause of the 5th or 14th Amendment. The Secretary does not contend that procedural due process is inapplicable to determinations of Social Security disability benefits. He recognizes, as has been implicit in our prior decisions, that the interest of the individual is in continued receipt of these benefits is a statutorily created property interest protected by the Fifth Amendment. Rather, the Secretary contends that the existing administrative procedures detailed below provide all the process that is constitutionally due before a recipient can be deprived of that interest. This court consistently has held that some form of hearing is required before an individual is finally deprived of a property interest, and the right to be heard before being condemned to suffer grievous loss of any kind, even though it may not involve the stigma and hardships of a criminal conviction, is a principle basic to our society. The fundamental requirement of due process is the opportunity to be heard at a meaningful time and in a meaningful manner. Eldridge agrees that the reviewed procedures available to a claimant before the initial determination of ineligibility becomes final would be adequate if disability benefits were not terminated until after the evidentiary hearing of the administrative process. The dispute centers upon what process is due prior to the initial termination of benefits pending review. Resolution of the issue whether the administrative procedures provided here are constitutionally sufficient requires analysis of the governmental and private interests that are affected. Our prior decisions indicate that identification of the specific dictates of due process generally requires consideration of three distinct factors. First, First, the private interest that will be affected by the official action. Second, the risk of an erroneous deprivation of such interest through the procedures used, and the probable value, if any, of additional or substitute procedural safeguards. And finally, the government's interest, including the function involved, and the fiscal and administrative burdens that the additional or substitute procedural requirement would entail. Since the recipient whose benefits are terminated is awarded full retroactive relief if he ultimately prevails, his sole interest is in the uninterrupted receipt of this source of income pending final administrative decision on his claim. His potential injury is thus similar in nature to that of the welfare recipient in Goldberg. Only in Goldberg has the court held that due process requires an evidentiary hearing prior to a temporary deprivation. It was emphasized that the welfare assistance is given to persons on the very margin of subsistence. Eligibility for disability benefits, in contrast, is not based upon financial need. Indeed, it is wholly unrelated to the worker's income or support from any other sources. As Goldberg illustrates, the degree of potential deprivation that may be created by a particular decision is a factor to be considered in assessing the validity of any administrative decision-making process. The potential deprivation here is generally likely to be less than in Goldberg, although the degree of difference can be overstated. In view of the torpidity of this administrative review process and the typically modest resources of the family unit of the physically disabled worker, the hardship imposed upon the erroneously terminated disability recipient may be significant. Still, the disabled worker's need is likely to be less than that of a welfare recipient. In addition to the possibility of access to private resources, other forms of government assistance will become available where the termination of disability benefit places a worker or his family below the subsistence level. In view of these potential sources of temporary income, there is less reason here than in Goldberg to depart from the ordinary principle established by our decisions that something less than an evidentiary hearing is sufficient to prior to adverse administrative action. An additional factor to be considered here is the fairness and reliability of the existing predetermination procedures, and the probable value, if any, of additional procedural safeguards. Central to the valuation of any administrative process is the nature of the relevant inquiry. In order to remain eligible for benefits, a disabled worker must demonstrate, by means of medically acceptable clinical and laboratory diagnostic techniques, that he is unable to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment. In short, this is actually a statute. I wouldn't call it a rule, it's a statute. Okay. Medically acceptable clinical and laboratory diagnostic techniques that he is unable to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment. In short, a medical assessment of the worker's physical or mental condition is required. This is a more sharply focused and easily documented decision than the typical determination of welfare entitlement. In the latter case, a wide variety of information may be deemed relevant, and issues of witness credibility and veracity often are critical to the decision-making process. Goldberg noted that in such decision, by contrast, and there's just so many ways of distinguishing this from Goldberg. Goldberg noted that in such circumstances, written submissions are a wholly unsatisfactory basis for decision. By contrast, the decision whether to discontinue disability benefits will turn in most cases upon routine, standard, and unbiased medical reports by physician specialists. To be sure, credibility and veracity may be a factor in the ultimate disability assessment in some cases, but procedural due process rules are shaped by the risk of error inherent in the truth-finding process applied to the generality of cases, not the rare exceptions. The potential value of an evidentiary hearing or even oral presentment to the decision maker is substantially less in this context than in Goldberg. A further safeguard against mistake is the policy of allowing the disability recipient's representative full access to all information relied upon by the state agency. In addition, prior to the cutoff of benefits, the agency informs the recipient of its tentative assessment, the reasons therefore, and provides a summary of the evidence that it considers most relevant. Opportunity is then afforded the recipient to submit additional evidence or arguments, enabling him to challenge directly the accuracy of information in his file as well as the correctness of the agency's tentative conclusions. These procedures, again, as contrasted with those before the court in Goldberg, enable the recipient to mold his argument to respond to the precise issues which the decision maker regards as critical. In striking the appropriate due process balance, the final factor to be assessed is public interest. This includes the administrative burden and other societal costs that would be associated with requiring, as a matter of constitutional right, an evidentiary hearing upon demand in all cases prior to the termination of disability benefits. The most visible burden would be the incredible cost resulting from the increased number of hearings and the expense of providing benefits to ineligible recipients pending decision. No one can predict the extent of the increase, but the fact that full benefits would continue until after such hearings would assure the exhaustion in most cases of this attractive option. Financial cost alone is not a controlling weight in determining whether due process requires a particular procedural safeguard prior to some administrative decision, but the government's interest, and hence that of the public, is conserving scarce fiscal and administrative resources is a factor that must be weighed. At some point, the benefit of an additional safeguard to an individual affected by the administrative action and to society in terms of increased assurance that the action is just may be outweighed by the cost. The ultimate balance involves determination as to when, where our constitutional system, judicial type procedures must be imposed upon administrative action to assure fairness. In assessing what processes is due in this case, substantial weight must be given to the good faith judgments of the individuals charged by Congress with the administration of social welfare programs, that the procedures they have provided assure fair consideration of the entitlement claims of individuals. This is especially so where, as here, the prescribed procedures not only provide the claimant with an effective process for asserting his claim prior to any administrative action, but also assure a right to an evidentiary hearing as well as to subsequent judicial review before the denial of his claim becomes final. We conclude that an evidentiary hearing is not required prior to the termination of disability benefits, and that the administrative procedures fully comport with due process. Conclusion. Justice Brennan, with whom Justice Marshall concurs, dissenting. I agree with the District Court and the Court of Appeals that prior to termination of benefits, Eldridge must be afforded an evidentiary hearing of the type required for welfare beneficiaries. See Goldberg v. Kelly. I would add that the Court's consideration that a discontinuance of disability benefits may cause the recipient to suffer only limited deprivation is no argument. It is speculative, moreover, that the very legislative determination to provide disability benefits without any prerequisite determination of need, in fact, presumes a need by the recipient, which is not this court's function to denigrate. Indeed, in the present case, it is indicated that because disability benefits were terminated, there was a foreclosure upon the Eldridge home, and the family's furniture was repossessed, forcing Eldridge, his wife, and their children to sleep in one bed. Finally, it is also no argument that a worker who has been placed in the untenable position of having been denied disability benefits may still seek other forms of public assistance.